Good morning, Your Honors. The matter before the court this morning is the case entitled Aerie Point Holdings LLC versus Vorsteveld Farm LLC, case number 24 AP 258. Representing the appellant, Vorsteveld Farm LLC, is Claudine Safar. Present with Attorney Safar is Mr. Vorsteveld. Representing the appellee, Aerie Point Holdings LLC, is Merrill Bent.
Okay, thanks. Good morning again. We'll hear from counsel for the appellant. Please introduce yourself, identify your client, and then proceed.
Good morning, Your Honors. My name is Claudine Safar. I represent the Vorsteveld Farm, and as mentioned, I'm here with my client. Your Honors, we are here on a second contempt determination by the Superior Court. As this court well knows, this court will uphold the trial court's findings as long as there is substantial evidence to support it, even though there is contradictory, credible evidence in the record. In this case, after reviewing the trial evidence, the court will see that the opposing party withdrew all of its exhibits with the exception of 3. The court mentioned that it would disregard evidence related to the July 10th storm event, which took lives and property in the state of Vermont. That July 10th storm event comprised the majority, if not all but one exhibit of the Aerie Point's evidence in this particular contempt proceeding. The exhibits that remained were exhibits 29, 30, and 31. If the court examines the record, exhibits 29 and 30 also related to damage from the July 10th storm event, which was flattened grass. If this court looks at the contempt determination, it cannot sustain this determination because there is no evidence in the record as to that our client did not comply with the court's order. If the court looks back in its injunction in the first contempt proceeding, it described the efforts that the Vorsteveld Farm made in formulating a plan to address the injunction as promising. It made this comment in 2 places in its decision. On page 6, Mark Bannon and Dory Barton were engaged to work on a, quote, promising plan to comply with the purpose of the injunction. Again, the court on page 7 calls the farm's plan, they have been able to develop a plan in a short period of time that, quote, looks promising. So in 2 instances, after hearing Mr. Bannon describe his plan to address the water leaving Vorsteveld Farm, the court calls this plan promising. In its subsequent determination after 4 days of trial, where we walked the court around and showed her $60,000 in improvements for 4 hours on a farm, she calls our efforts meaningless, Your Honor, that they were a lack of meaningful effort to comply. $60,000 and 4 hours of effort to show her all of these improvements lacked any meaning. When the court listened to all of this evidence and listened to these plans and termed these plans promising, it's also really important to understand that this court will not support findings of fact that are clearly erroneous, and they are clearly erroneous if they are illogically and internally inconsistent. This decision does both. On the one hand, it terms the injunction as addressing excess water. It does this numerous times in its decision, which is approximately 30 pages long, and guides our understanding of the injunction. We asked the court for guidance on this injunction numerous times. It then told us to file a 60B, which it subsequently denied. The farm did its best to address the issues that were raised by Aerie Point, and spent a significant amount of time and money addressing these issues, which then the court, on the one hand, told us that we needed to stop all water, but in the same breath told us that the point of the injunction was simply to address—
1 minute, counsel, 1 minute.
excess water. I would direct the court to page 7 as an example. Second, the plain meaning of the court's decision and related injunction is that the water to be enjoined that would not be running down slope in the stream beds to the ditch if no tile drains had been installed on the farm's land. This is not all the water that comes out of the tile drains. All the water is coming out of the tile drains is not excess water. The court says that's 10 to 25% of a number that we do not know. The court then determines that it is all the water from the tile drains that the farm must stop. And that is not consistent with its own decision. It's not consistent with any expert testimony in the record. And moreover, Aerie Point never presented any evidence that it was all the water that needed to be stopped. In fact, the last time we were before this court, Aerie Point admitted that the injunction was just simply there to address excess water, not all the water leaving the tile drains.
Okay. Your time has expired, counsel. Thank you. We'll hear now from counsel for the appellee. Please, for the record, introduce yourself, identify your client, and then proceed.
Morning, Your Honors. Meryl Bent for Appellee Aerie Point Holdings, LLC. May it please the court. I'm going to start by just addressing a couple of misstatements that I heard in appellant's argument. The first being that all of the exhibits all of the plaintiff's exhibit except 3 were withdrawn. Just to point out that there were numerous exhibits presented in rebuttal testimony, I think 9 or 10 photo and video exhibits from July 16th. Which was a different date than the July 10th storm. The July 10th storm photos were withdrawn simply because that was a uniquely severe storm and we sought to avoid confusion in the case. The other point I would address is the claim that there was $60,000 spent on compliance. If the court examines the record, you'll see that much of the $60,000 cited was actually geared towards the work that was performed in connection with the EPA action against the farm. And actually a lot of the time that was accounted for experts testifying in contempt proceedings. As the court knows, the trial court's finding of contempt is reviewed for an abuse of discretion, and the trial court's factual findings must be upheld unless there's no credible evidence to support them or they are internally inconsistent. Here, there is a robust record of extensive evidentiary hearings on the plaintiff's motion for contempt, which occurred over more than 6 days in December 2023 and July and August in 2024, and which included a site visit. The trial court made extensive findings of fact, which are supported by the record, and which are consistent with the trial court's prior orders and with this court's decision in the prior related appeal in 2024 VT 29. Aerie Point met its burden of demonstrating the elements of contempt, that the defendant knew what the order required of it and it failed to comply with the order. This was established through testimony as well as photographic and video evidence, and it was also supported by the lack of evidence of meaningful efforts to comply with the plain language of the injunction. The farm, as the trial court found, failed to meet its burden of demonstrating compliance with the injunction or any defense to contempt. The farm's expert acknowledged that his plan was premised on a misinterpretation of the injunction that was contrary to its plain terms. The farm's witnesses confirmed and acknowledged that the measures they had designed were not intended to prevent water from the tile drains from reaching the ditches and culverts along Arnold Bay Road and ultimately Aerie Point. And they failed to demonstrate any meaningful ameliorative effect of those measures. The farm's new interpretation of the injunction was contrary to its plain language, prior orders of the trial court, and even this court's analysis in the May 2024 decision. The court should rely on the trial court's assessment of the credibility and weighing of evidence and affirm the trial court's contempt decision. Unless the court has any specific questions, the appellee will otherwise rest on the arguments set forth in our brief.
Okay, I don't see any hands. So thank you very much. Does the appellant have time?
Appellant has no time remaining.
All right, thank you both. Please call a conclusion.